My name is Jeff Morgan. I'm from Dallas, Texas. I've been asked recently, what was it that caused the 11 out of the 12 jurors to side with the mother in the Save James trial case? So I have notes, extensive notes on this, but I'm going to try to briefly condense what I saw took place. But I think before I even go to that, I'm going to have to go to the opening day arguments. So the opening day arguments really laid the foundation for what may have influenced the jury in the end. There were two attorneys there representing the mother. They were co-counsel. That would be Jessica Janicek and Laura Hayes. They were from the KoonsFuller law firm. For the father, there was Logan O'Neil, and then there was the amicus attorney, Stacey Dunlop. Now, the first people to present their arguments were the attorneys for the mother, and what they stated was that the 7-year-old son, known as James, has gender dysphoria. Is this a phase? We don't know, they said. But the case is not about gender dysphoria, it is about parenting. Now, after stating that it was about parenting and not about gender dysphoria, she therefore tries to paint the mother as being the wonderful parent and the father as being perhaps a little bit unstable, unloving, not supportive enough, mean, vindictive, and perhaps even a little bit criminal, as you will see as I read through what they laid out in their opening arguments. So first off, she has to say is that mother follows the recommendation of the experts. The father does not. When you come later into the trial, you will understand why the father did not believe or follow the recommendations of the experts. Some of them seem to be very ideologically motivated, and the mothers whose ideology may have aligned with theirs was very happy to follow their recommendations. After that, they presented Luna. Now, Luna is a fictional name. It is a name given to a 7-year-old boy whose legal name is James. He is a boy, and his legal name is James. Somehow, during the earlier part of his life, his mother and two of the mother's daughters found this name, Luna, on the internet, and they gave it to James. James apparently was accepting of it, according to the mother's testimony. So now we have a boy, legal name James, now being called Luna and referred to as she by the attorneys for the mother. The attorneys also mentioned that the court's decision was that mom has exclusive rights and possession. Dad has limited access and possession to the child. If you notice, why did the court find this? Somehow the mother was better than the father. In family courts in Texas, there always has to be a winner and a loser. That's just the way that it works. And so somehow the idea is that if somebody has won, that person is the better person. That's often very, very far from the truth. So mom has exclusive rights and possession. Part of that responsibility is that mother takes James to the Genesis Center. The Genesis Center is an affirming care center for transgender or gender diverse youth who experience gender dysphoria. Once again, gender dysphoria is mentioned, even though this is not the basis of the case. They assert gender dysphoria, which was never proven. In fact, by definition, James did not have gender dysphoria. But again, in order to keep the narrative of the good mother going, the mother has taken James to the Genesis Center where they provide gender-affirming care. In addition, the mother, who has sole and exclusive rights to choose counselors, has chosen Rebecca Orr for James. Now, Rebecca Orr is mom's choice. The dad does not agree with the choice. The dad has no say in the matter. Rebecca Orr is a published author and therapist, and her work specializes in work with LGBT individuals, couples, families, and youth. She specializes in gay, lesbian, and transgender. This good mom, in affirming her son once again, has also enrolled James, I should say Luna, into school as a girl called Luna. Now, the administration and some teachers know that James is really James and he's a boy, but they seem to play along with the delusion. They affirm him as Luna. I take that back. They affirm her as Luna because she presents herself as a girl, and that's all that they know her as. James participates in girl activities. James wears dresses. James sometimes has fingernail polish when he goes to school, other things that are very feminine. And the school is affirming of this. They should be reporting it. It turns out that on March 8th, 2018, during the father's possession time, he decided to take James to the school for an open house. It was an open house. He had possession of the children. He wanted to meet the teachers in the school, know about the curriculum. But the father took James to school as a boy. The mother is against this. Why? Because everyone in the school knows him as a girl. And the mother is upset that perhaps this delusion, this fantasy, is going to come crashing down. The father does this, and dad has supposedly humiliated the boy. The mother files lawsuit. because the dad is trying to hurt the children. And by the way, the attorneys later on showed a video clip of this open house, which I believe that the amicus attorney Stacey Dunlap really misused. What was taking place there was a Texas jail felony violation. If you look at the Texas Penal Code, Section 25.03, interference with child custody, the father had the possession time, the mother took the child away, and the amicus attorney completely whiffed on that one. He was good on many, many things, but the amicus attorney really, really whiffed on that one. So all Dad is wanting is a second opinion about the so-called apparent gender dysphoria. Once again, gender dysphoria has never been established. It does not meet the criteria to say this is legitimate gender dysphoria. But instead, Mom goes out and gets 3 second opinions. All Dad says is he wants a second opinion that has not been doctor shopped, as we know can't very easily happen. Dad starts to post information online after this lawsuit is threatened against him. Now the attorneys have to claim that Dad is living off of the money from the website, and he's not reporting it to the IRS, and he's using it for personal purposes. He claims he's using it for legal fees and things related to James, which he actually did do, but the attorneys have to somehow try to portray him as being perhaps a little bit criminal in his activities. He's a fraud. He's not reporting money to the IRS. This is their line of attack. The issue is not about the medical transition. It's not about who gets to choose or make medical choices for the son. It's about who is the better person. And by making sure that the mother is the better person, you have to demonize and slander a good person, whether it be a father or a mother on the opposite side. Finally, the attorneys argued that there is a custody evaluator, Dr. Benjamin J. L. Britton, and Dr. Benjamin J. L. Britton is very sensitive to children. Now, Dr. Benjamin J. L. Britton has stated that Mr. Younger is not acting in the best interest of the children. It's amazing how this best interest of the children doctrine comes up all over the place. Now a child custody evaluator knows what the best interest of the child is. And in accordance with Dr. L. Britton's report, from what I could gather, he was advocating that Mr. Younger socially affirm James in this transition that the mother was imposing upon him. What I found interesting was that one of the expert testimonies that came up later on, Dr. Stephen Levin out of Case Western Reserve University, testified that he looked at the custody evaluation report and he made a single statement. I believe it was on page 68 of the evaluation, said based on the statement alone, he knew that Dr. Benjamin J. L. Britton did not understand the issues that he was making a recommendation on. So here we have a semi-ignorant child custody evaluator who got paid well over $20,000. I really wish that Dr. Benjamin J. L. Britton would publish how much he got paid for this child custody evaluation report. But he is making a recommendation supposedly on the best interest of the child with faulty information. He's recommending that the father attends 2 years of individual psychotherapy class, and also that the father go to classes in transgenderism or something along those lines. So those were the arguments presented by Ann Georgelis's attorneys, again trying to somehow portray the father as being a not fit parent. Somehow there's something wrong with him. Somehow there's something that, Dr. Ann Georgelis is the better parent, so jury, you need to make sure that the children stay with the better parent. Next came up Logan Ordonil, the attorney for Mr. Younger. Now, Mr. Ordonil actually framed the question correctly. Which party has the rights to make the transition decision regarding the child? And as he started to lay forth his case to the jury, he said, number one, that Ann is preparing the child to be medically transitioned. Ann has Facebook pictures with James dressed both in boy clothes and girl clothes, and even on her medical website, Dr. Ann Georgelis had pictures of James both as a boy and as a girl. He further alleged that Ann is transitioning the son right now by taking affirmative social action with James. So when she enrolled him in school as a girl, gave him a new name, Luna, started putting him in dresses, had fingernail polish put upon him, sometimes gave him eyelashes, other things that would try to affirm a female identity, which he never expressed around his father, that somehow that because she was doing this was actually leading him down the road that would later lead to puberty blockers, cross-sex hormones, and eventually medical transition surgery in which the genitalia of James would be that would be changed to align with his so-called newfound gender or sex that he wanted to be identified with. The puberty blockers used in the transition process are an off-shelf use of the drugs. They are not FDA approved for this use. The drugs that were used, and I believe it's Lupron, was designed to stop early onset puberty. There is no FDA approval for this drug to be used for transitioning purposes. People have asked me if Big Pharma is financing Dr. Ann Georgelis in this trial. I don't know. I know there is a lot of money to be made here. I did not get that impression, but I don't know what goes on behind the scenes. So if they aren't, I can't tell you. I really don't know about that. I can't speak to that. He also talked about cross-sex hormones. Cross-sex hormones have to be taken for life, and cross-sex hormones will lead to irreversible medical harm. And then, of course, if you go to the medical surgical part of it, in which you remove a boy's genitalia and reconstruct him with new genitalia, can you imagine that? What that does to a person, especially when it's being forced upon him and led down that road by a mother at an early age. Mr. O'Neill did mention that there was a 13 or 14-year-old recommended, and I believe it was by the Genesis Clinic, a 13 or 14-year-old girl who was recommended to have a double mastectomy. At 13 or 14 years of age, she was recommended to have a double mastectomy. And the argument is that this is the type of path that Ann Georgelis is leading James down. First, we socially affirm them. By socially affirming them, you increase the chances by a large amount that they will later on get their puberty blockers, cross-sex hormones, and then have some type of surgery which will accompany it later on. Somehow, Ann does have exclusive rights to the medical decisions. And by the way, these rights were granted by Kim Cooks, the judge in front of whom they were appearing. Mom's decision is detrimental to James, and Dad just wants a second opinion. Yet if Mr. Younger takes James to a doctor to get a second opinion, apart from one of these doctor shop doctors that Ann Georgelis has found, the mother through her lawyer is threatening a second lawsuit against Jeff. And by the way, the lawsuit that has taken place beginning a couple of weeks ago was filed by the mother. The mother was asking for a modification of the father's visitation rights in accordance with Chapter 156 of the Texas Family, or as I often call it, the Texas Anti-Family Code. The Texas Family Code is a part of the problem behind these lawsuits that go on. And that needs to be recognized by our governor, by our legislators, by our attorney general, by all people concerned. You need to fix the Texas Family Code. It's broken in many ways, and this type of abuse, as much as we protest it later on, has been enabled by the Texas Anti-Family Code. So in accordance with the modification, the mother wants the dad's visits with the children to be curtailed. Did not want them to be eliminated completely. She believed that, the father still had some good things to say, but did not want the father to have too much influence in the children's lives. She wanted his access to be restricted yet further and perhaps even supervised, if I understand the order correctly. But I believe that she also wanted to have some of his visitations with the children supervised. She also stated that Mr. Younger should be ordered not to call his son by his legal name. Instead, Mr. Younger should be calling James by the fantasy name Luna at various times. Jeff cannot treat his son James as a boy in all instances at all times. And by the way, Mr. Younger was ordered not to call his son by his legal name, and this was done in the 255th District Court by Associate Judge Scott Beecham. His name reads like Beauchamp, B-E-A-U-C-H-A-M-P. Scott Beecham actually put forth that order, if I remember reading it correctly. Mr. O'Neill then also stated that transitioning a boy, a 7-year-old boy such as James, is not an innocent procedure. It is insidious. It is insidious evil. There are psychological, psychiatric, and medical issues that are involved in this, and these will last for his entire lifetime. Most children, if left alone and taken a watch and wait approach, as opposed to a let's affirm him socially approach, the social affirmation approach is much more in line with the LGBT agenda, but the watch and wait approach is much more in line with what the experts actually recommend. Watch the child. Usually by the end of adolescence, the child resolves his or her supposed gender identity issues. And up to 90% or more of the cases that takes place. In the cases where it doesn't take place, get him or her psychological counseling at that point. The issue is not an issue of biology, it is an issue of psychology. So if it is a psychological issue, why are we doing why are we treating this thing as if it is a biological issue? Why are we given puberty blockers? Why are we given hormones? Why are we affirming a person's delusion to have his or her penis cut off or to be reconstructed with the penis? It makes no sense to me whatsoever. There is also a disorder called body integrity disorder, I believe it's called, where somebody with a perfectly good functioning arm may just say, I want to be an amputee, and goes to a doctor and wants his arm cut off or a leg cut off, or maybe to somehow, can you induce paralysis to me so that I'm stuck in a wheelchair? We look at these things and we say, this is crazy. It's a psychological issue. A doctor who would go in and say, well, I'm going to cut off his arm because he wants it today, I don't know, but I would assume could be sued for medical malpractice. And yet, when it comes down to issues of gender, supposedly, we will allow people to have their penises cut off and be given fake vaginas, or do whatever they do with women, like, so for example, the double mastectomy, and say, well, that's okay. This is something that's completely crazy. The question that Mr. O'Neill presents before the court is this: which party has the right to make the decision regarding the child? The mother's decision is detrimental to the child. It is harmful to the child, not just in the immediate, but in the long-term future. But there's another party that needs to be considered in this whole situation as well, and that is James' younger brother, his twin brother, Jude. Jude has had to lie to people about his brother. Jude has had to tell people that his brother is a girl when he knows that his brother is a boy. What does this do to Jude? What are the impacts upon Jude when he has to lie, when he has to affirm a lie? Something that he knows is not true, and he's got to be part of this lie. What is this doing to Jude? How damaging is that to Jude? These are the issues that are at stake. Amicus attorney Stacey Dunlap, he basically said he was there for the court and for the children. I will say that for the most part, Stacey Dunlap did a really great job on his closing argument. I think he completely missed the point. I think he completely blew it. And I gave him a copy of the 2503, the interference with child custody, which he seemed to look at and like say, oh crap, because he really blew that part of it. Anyway, that's the background to these are the way the two different parties were arguing. One was arguing to say that the father is bad, 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 therefore you have to rule against the father. The other one was trying to say it's the medical decision that we need to consider. What is the medical decision? And in the course of the medical decision, he was also able to defend the father, because a lot of these things that were being stated about the father were actually false, were innuendos, were insinuations, were completely proven false, but that doesn't make a difference. If you keep asserting the lie long enough, maybe people will believe it. Anyway, so that's the background to the jury decision. I will try to get to the jury decision either later today or very soon to what I perceive to be the motivations behind the decision. I was not in the jury room in the deliberations. I don't know what was going through their thoughts. I do, again, believe that the amicus attorney at the very end threw the case. That's my opinion, but I will give my feedback on that later. Thank you very much.